Good afternoon and welcome everyone. Thank you for being here today. For the final session of the virtual workshop series, 3D Firearm Imaging, we are joined today by presenters Raymond Valerio, Director of Forensic Sciences at the Queens County District Attorney's Office, and Erich Smith, the Technical Leader and Physical Scientist Forensic Examiner with the Federal Bureau of Investigation Firearms and Toolmarks Unit. Without further delay, I will hand things over to our presenters. Thank you.
Today, we're going to talk about 3D firearm imaging, and specifically as it relates to testimony and admissibility. Just want to note that some products will be discussed during my portion of the lecture. I have no financial interest in any of the products that are mentioned. So, over the last 5 years, across the nation, legal admissibility challenges have spiked in firearms identification cases. Thankfully, despite the numerous challenges, nearly all courts have permitted the prosecution to offer this evidence in trial. But all of these challenges have involved traditional light comparison microscopy. Today, we will discuss the impacts of 3D firearm imaging on legal admissibility and testimony. So will 3D firearm imaging have the same acceptance in courts as traditional light comparison microscopy is really the question. Now, this is not the first time that FTCOE has tackled 3D firearm imaging technology, but now in 2024, we're starting to narrow the scope. There have been validations, there's been trial testimony. So what are we going to talk about today? In my portion, I'm going to discuss admissibility and what I foresee as some future impacts of this technology. Under that umbrella of admissibility, we'll discuss the Federal Rules of Evidence, Section 702, and the legal standards that apply. So the Federal Rule of Evidence 702, the 2000 version, is one that we're more familiar with. This has been in place for over 23 years, and this is what it said. The expert opinion is admissible if, and then it goes through these different points. I'm not going to read through all of it because this is no longer the rule. The rule changed in December of 2023, and there are some nuances to the rule that are important to know. So now it adds in the preamble, if the proponent has demonstrated by a preponderance of the evidence, so there's that portion. But the more important portion is at the end in section D, where instead of just focusing on the principles and methodologies, now the court is to look at the expert's opinion and that reflects a reliable application of the principles and methods to the facts of the case. So it's a slight nuance there, and we'll see how courts begin to analyze different forensic disciplines, particularly 3D firearm imaging, through this new lens of the Federal Rule of Evidence. Now let's talk about legal standards and combine that with the Federal Rule of Evidence. So when we look at 702, we see certain words here, and those words trigger the different legal standards that apply. When we look at the word scientific there in subsection A, that should remind us of the Daubert standard. Daubert discusses scientific evidence. But now when you look at some other words, knowledge, skill, experience, training, and then later on in subsection A, technical or other specialized knowledge, this may trigger us thinking that this is relating to cum hotire, another legal standard discussing the admission of forensic evidence. Let's first talk about Daubert for a moment. And I think the Daubert standard is familiar to most of us. Basically, instead of relying solely on general acceptance within the scientific community, the court in Daubert enumerated a list of factors. That general acceptance standard, I'm going to just pop up there on the side, was the Frye standard. Now, Frye is still the legal standard in many states. in the US, New York, there's a version in California and several other states, but the predominant legal standard is Daubert standard as it relates to forensic science evidence. Now, in addition to the general acceptance, there's this list of factors that Daubert discusses. Now, let's talk about those standards and factors just for a moment. Of course, there's the general acceptance, but there's also the testability of that method, the peer review and publication of that method, known or potential error rates, and standards and controls. Even just a moment ago before this meeting, I was on the OSAC Firearm and Toolmark subcommittee discussing the development of standards. And we're talking about these precise things. Courts want to see standardization because that gives more credibility and reliability to whatever scientific discipline we're discussing. Now, I'm going to give you a little excerpt here from a Daubert hearing that happened in the Southern District of New York. In this case, this is U.S. v. Johnson. This is what the judge said. The detective from the NYPD who conducted the analysis using traditional light comparison microscopy, court said that he had this specialized technical knowledge. He did not present himself as a scientist. His expertise is grounded in training and practical experience rather than academic study. Now, that doesn't sound like a Daubert standard. It doesn't sound like the court is looking through the lens of Daubert. This sounds much more like Kumho-Tyre. Kumho-Tyre was a case where it wasn't traditional scientific discipline. And what Kumho said is that even a non-scientific expert testimony falls under Rule 702, but still the court must assess whether the expert employs the same level of intellectual rigor that you would expect using the same standard in Daubert. So in other words, we're looking at the same factors, but it's looked through a different lens as non-scientific expert testimony. Now, we're going to come back to this later on, I think. So that's just a very brief overview of admissibility and just some cases that discuss it. I want to spend the bulk of my time discussing future impacts. And for that, we'll discuss the methodology that's being used and statistics. So when we think about methodology, we have to compare LCM and VCM. Now, we're familiar with the optical microscope, and we have 3D technology that's now available. Erich, during his portion of today's lecture, will discuss in more depth how the same method is used, whether it's LCM or VCM. Just that VCM uses a different instrument to conduct the same analysis. Now, what I want to do here is use analogies to try to describe this similarity. And analogies are really important both for the lawyers who are not scientists, who are not practitioners. It's important for the court to understand by way of analogy. And if necessary, it's important for a fact finder, like a jury, to understand these things so that they appreciate maybe the differences that are nuanced between LCM and VCM, but that the methodology is still the same. So to do that, I would just want to paint this picture using the evolution of the iPhone. Now, new phones have more features. In fact, Apple just unveiled a new iPhone, again, just this week. Those new features may include better resolution and different functionality on the phone, but when you click on your phone, you want to dial mom to call her up, she's still going to answer the phone. So whether it's an old phone or a new phone, it still does the same thing, maybe faster, it may have some additional features and bells and whistles, but it still does the same function. In other words, there's nothing new about the methodology of VCM as compared to LCM. They're going to use the same AFTI standard. Of course, with VCM, there's going to be the ability to orient the ballistics to some degree, but the examiner still must conduct analysis. And another analogy is helpful here, just to kind of paint this picture a little bit deeper. Because of its improved resolution, VCM is basically a tool that enhances the examiner's ability to discern details previously unavailable using conventional LCM. What would the analogy be there? Well, maybe you play golf. I'm a very part-time golfer myself. If the golfer swings a new club the same way as an old club, but the new club has some new technology. It may have a new type of shaft, maybe a graphite shaft. It may have perimeter weighting, other technology. It enables the golfer to hit the ball farther, maybe more accurately, hopefully. But the elements of the game and the golfer's swing are largely unchanged. And to take that analogy a little bit further, VCM does not make a mediocre examiner better. Just like a new club doesn't make me a better golfer. I still would need to strike the ball correctly, just as a VCM examiner would still need the requisite training and experience to achieve reliable results using VCM. Now, maybe you're familiar with this report that just came out a few months ago from the Texas Forensic Science Commission. There was a complaint that was filed against the Houston Police Department lab that's no longer in existence regarding identification of ballistic evidence. Now, of course, it turns out that it was a identification. It was improper. It became this long investigation, and a report came out of it. I'm not going to get into the details of that, but there was something of note that was found at the end of this report. And it was how the Texas Forensic Science Commission touted VCM as technology that they're strongly encouraging labs to adopt. Talks about the potential advantages of VCM and makes this note here that compared to traditional images, the VCM data are more repeatable and not sensitive to lighting conditions and can be compared by both algorithms and examiners. It goes on and makes more statements regarding it. It encourages labs to find funding either through grants or from the federal government to adopt this type of technology. And this is important as it relates to future impacts because this is the way things are headed. Now, what I want to talk about, which is maybe the more uncertain part of where we're going with VCM, is statistics. And this is the question that I want to pose to begin this section. If 3D technology uses the same methodology as LCM, where do statistics fit into the discussion? Right? Of course, we know if a lab uses 3D technology as simply a more robust way of conducting a comparison, there shouldn't be any basis for a legal challenge. They're just, again, using the same methodology with a different instrument. However, most of the tools, the VCM tools, also have features to provide a quantitative statistic associated with the qualitative opinion of the expert. And this is where this concept of statistics comes into our analysis. So how do we approach this? Well, let's think about things that are currently out there. We're familiar with the NIBIN system, the National Integrated Ballistic Information Network. It's a good example. Sometimes people have asked, well, what's the difference between a NIBIN association, which is using an algorithm to suggest similar ballistic evidence, similar casings? So what's the difference between a NIBIN association and what a 3D VCM statistic can say? Even some attorneys or law enforcement officials have asked me, well, can a NIBIN lead be used for a grand jury presentation or a trial? Because it's an algorithm that's suggesting what the closest match or what may even be a match. Can we use that? Well, here in the NIBIN toolkit, it explains that NIBIN is not a computer system that spits out an expert report. Rather, it employs a technology that finds likely matches. In other words, NIBIN is not equivalent to what an expert examiner, whether it's under LCM or VCM, is able to say. It's a lead. It's not a conclusion. It's not an opinion of the expert. So that doesn't really help us that much. And that's where I want to talk a little bit more about statistics. Now, I'm going to mention a likelihood ratio here and just say this is not a statistics lecture. We're just going to touch this at a very high level. What is a likelihood ratio? It's the probability of seeing evidence if that evidence, let's say it's in a DNA statistic, is from the defendant versus an unknown individual. And a likelihood ratio in firearms would be similar. The probability of seeing this evidence if it's from this firearm versus an unknown firearm, okay? But this is the way it's would be phrased in DNA. The DNA result is approximately 195 billion times more probable if the sample originated from John Doe than if it originated from an unknown person. So in other words, the likelihood ratio is given an evidence result, which scenario is more likely? And I want to just stick on the topic of DNA for a moment. The validation would show data. And here is the New York City DNA Labs validation summary as it relates to their probabilistic genotyping software and issuing likelihood ratios. So from 0 and down, likelihood ratios that are in this negative log LR, that would suggest that it's an exclusion based on their validation. There's a small uninformative range where they can't say one way or another. And then once it exceeds a certain likelihood ratio, that's considered an inclusion. So the question is, well, what about statistics as it relates to pattern matching disciplines and firearms specifically? Well, I think here we need to look outside of DNA, and we need to now look for if it has been applied in other pattern matching disciplines. See, it's always good to look to see if others have gone before us to blaze the legal trail, so to speak. Here, I want to just refer back to a presentation that was given back in April of 2018 through the FTCOE regarding FRStat. This is a software used for friction-ridged skin. In this presentation back from April of 2018, it said the tool is intended to provide a statistical estimate of the strength of evidence to be used in conjunction with the examiner's own conclusion. In other words, there's that qualitative statement. It's a match, it's an inclusion, it's a source ID, whatever the terminology that we're using, that's the qualitative side. But then this tool is able to provide some quantitative number to support that qualitative statement. This was developed by Dr. Henry Swafford while he was at the Defense Forensic Science Center. To date, there has not been a legal admissibility challenge on FRStat. And while the software has been downloaded numerous times, no other U.S. forensic friction ridge labs have applied FRStat in casework. So we haven't had that Daubert, Kumo, or Fry challenge to FRStat. Well, have there been other statistical softwares used in pattern matching? Well, U.S. Secret Service has a system. It's called the Forensic Information System for Handwriting, also known as FISH. The program compares handwriting characteristics on threat letters with the goal of associating with other letters, cases, and known subjects. But again, this software has not faced a legal admissibility challenge yet in court. So we don't know how courts have viewed these types of statistics. Now, in the firearm and toolmark space, there are several algorithmic tools that have been and are being developed. Like the other pattern matching tools that I've mentioned, the statistical features have not faced legal admissibility challenges to date. But I want to note something that was published in Physics Today just a couple months ago. The article was titled "Firearms Forensics is Becoming More Quantitative." And there's some interesting quotes from this article. Someone from CSAFE, Alicia Karakwiri, who runs CSAFE, said the results of this 3D technology is promising, and she expects to see some changes in the way evidence is evaluated in the next few years. She goes on to say, to set probabilities for source determinations, scientists at Cadre and researchers elsewhere are working on analysis of 3D images of bullets from which, quote, you can look at the depth and position of striations And she notes that the algorithms do not always work, but some guns, because some guns don't mark, but she puts it, crappy guns that most criminals use mark nicely, and the accuracy and identification is high. There's quotes from Robert Thompson from NIST. He discusses how 3D imaging will augment the examiner's subjective opinions with objective data. It will increase confidence for juries. So my point in sharing this is that the forensic statistical community seems to be embracing these algorithmic features. Pattern matching disciplines like firearms and toolmark analysis has been criticized for its subjectivity. So adding this layer of objectivity may assuage some of those concerns. And this brings us back to what I mentioned earlier regarding 702 and legal standards. It seems like the direction that we're heading is that 3D firearm imaging is a little bit of both. It's a little bit of Daubert, it's a little bit of Kumo put together, and we're going to have this evidence challenged and admissibility hearings to be conducted for us to see how courts address these issues. And I just want to note, in closing, that the Advisory Committee on Evidence Rules have been considering amending Rule 702 yet again as it relates to machine learning and artificial intelligence. They're considering these new rules, and of course, the rules really are determined, the impact of the rules are really determined based on how machine learning and AI are defined. So will machine learning and AI, as they define it, somehow touch on the 3D algorithmic results? That remains to be seen. But that may be a significant future impact that we're going to have to keep our eye on. So with that, I'm going to pass the time over for Erich now. Thank you.
All right. Can people hear me? Can I get a call back?
Yep.
All right. Ray, I really appreciated that presentation. It kind of made me nervous a little bit. I'm Erich Smith. I'm a firearms examiner at the FBI laboratory, and some of you may already know me. But today I'm going to kind of walk you through how we adopted VCM in our laboratory, how it actually moves through the examination process, the methodology, and then how we present it in court. And then most recently, 2 admissibility hearings that I've been involved with that involved VCM. So with that, let's move forward. Got a disclaimer just like before. We're going to talk about, or you're going to see a lot of instruments. I'm not endorsing any particular instrument, and this doesn't represent any type of legal expertise as far as this presentation. All right, here at the FBI lab, it's going on over a decade now. We invested heavily in a lot of different instruments, and this is kind of an array of ones that we have in-house. And I know that the community is very interested. If not, they've already bought an instrument, or they're looking to buy an instrument, and they're not certain where to go and which one would work best in their process. What I would just tell you or inform you is that they come in 2 packages, and I basically consider them either contactless or they are contact. So some instruments may come in contact with the evidence to create the scan, and others may be just optical instruments that scan in a plane and give you a 3D rendering. But for your knowledge, when we ventured down this path, we really didn't know where we were going to go, but we did land on the Cadre system as the first one that we validated in-house. And that's where we're going to start off with. Okay. So imagine this is over a decade ago. There were no plans in place like we have now with OSAC, like Ray mentioned. OSAC is actually working on a virtual comparison microscopy standard to include the technical working group for 3D technologies is working very hard as well to provide documents to the community to understand what they need to do to develop a sound validation plan. But back when I started out, we didn't have any path. So I basically just started creating a bank of different tests to evaluate the instruments. I was really keen on the instruments. To be quite honest, I was skeptical of the image. Was the image truly a good facsimile of the actual real image or the real specimen? So we spent a lot of time evaluating that prior to actually pushing them out into testing. And so what we did is we used proficiency tests, a whole bank of them that we have in-house. We also created a series of best known non-match sets with consecutively manufactured slides that we have in our reference collection. And then we also evaluated casework. So we actually went back, cases that had already been issued using LCM, they were also scanned and examiners gave their opinion on that. So a lot of detail, a lot of information collected, and you can see that we have over 3,400 comparisons before we're actually even using it in casework. We had no false positives. We did have one false elimination, but otherwise it seemed very good and fit for purpose. And so from that, we thought we were off and flying. We definitely felt like we had a good system to work with. So after all the testing, my question to you would be, well, do I have to create a standard operating procedure for VCM? And there's a lot of debate on whether that should occur. And in the end, I made a decision that no, there didn't need to be an operating procedure solely for VCM. And what I'm illustrating here is this is actually from our procedures in-house. And we have a call out, and you can see, if you look at the footer, this is actually nestled within our ammunition and ammunition component examinations. So within that framework of that document, it says, okay, if you're going to use a 3D instrument, it's pretty much up to the examiner's discretion if they choose to use it. And then we also have call outs for re-examination. With these new technologies, there's definitely a want to go back and look at things that may have been inconclusive to see if the opinion would change. Just like Ray was suggesting, I'm using an iPhone 15 versus a flip phone. I might have better results in the end. I will tell you though, once this got written, we tweaked it a little bit. So now anything that comes through the door that is cartridge case, firearms based, they kind of get funneled right to VCM. So we have people designated in-house that will actually scan them up front so that they're already kind of in a cache for examiners to pull from. So they're kind of pending. And so as we started to move along in the process where we're actually doing casework, now there became questions about, well, what is a digital scan? And what are you physically evaluating? And this goes into regards to discovery. We have had discovery requests where the defense actually wants the files, the scan data, because they want to evaluate them as well. And so for firearms examiners, it was a big departure to understand that I am making an opinion where I don't physically have the samples. I'm not touching them. And so you had to give them some reassurance that, hey, there are other disciplines such as DNA and latent prints where the examiners are making opinions, but they don't physically touch the evidence. So there was this kind of bridge that we had to make, but we do retain all the files. And so this is what we do with them. They are retained in our system, and they are considered part of the laboratory file. And for our laboratory, all of our nomenclature falls under what's called a 1A file, but they can be retrieved if needed be for discovery. So that is something that we learned along the way. It's not something that, we kind of understood that this was probably going to happen, but we kind of built it out as we were moving along. So let's talk about the methodology. So LCM versus VCM. So in our lab, first thing it comes in, it can be designated as LCM or VCM right off the bat. And then there can be the classification straight up, and where we can, we have two different class characteristics we can eliminate. But you can see along the way, something can be pulled at any point and shift over from LCM and VCM and vice versa. And I'll be honest that when we kind of mapped this out originally, we did have a breakdown in our VCM methodology. I've didn't take into account that I could be doing VCM and I could be inconclusive. And we kind of had a breakdown where it stopped at that point. So we had to think about our SOP again, and we decided, hey, if I'm inconclusive using VCM, that is now forcing the examiner to go back to LCM to look at other areas that may not have been available for comparison at that time. And the inverse is true as well. If I'm inconclusive using LCM, I now have to go to VCM to finish out the totality of all the tools that are available to evaluate the tool marks to see if I can render a source conclusion opinion. So part of the process when we issue a report involving VCM, we have methods and limitations that go along with our report. So this is from our report writing language. And I really want to point out the second paragraph, because the whole limitation reads as if it were traditional LCM, but there's just this one call out to, in this case, VCM was used. And it points out the limitations when using VCM, that you're only looking at one plane necessarily. It might be the breech face or the firing pin. And so I don't have the case, the chamber marks to work with, or the extractor mark. These things are not present. So we had to make that known to the reader that, hey, there are limitations to using VCM. To include, there could be interfering substrates on a item, such as lacquer, that is obscuring the actual tool marks. So that is actually how our report would read. We have training and competency testing for qualifications for using VCM. So at the bottom left, actually this is the top paragraph is from our training manual. But for new trainees, they actually learn about the instruments that we have. They learn to some extent how to operate them. Now, our lab has chosen to kind of bifurcate the tasking. The examiners are not, they're not qualified to do scanning. We have technicians that do the scanning, but the examiners learn about the operation and how to manipulate specimens and move them about and record their conclusions. As you can see down below, this inlay, this picture on the left, these are all the virtual comparison packets that we have within our system that can be used for competency testing. And then the image on the right is a proficiency test. So this is actually how a competency test would look for qualifications. For a competency test, everything's built on a one-to-one comparison. It's not a closed set or partially open set. It is an open set test design. So a trainee will be given 2 known samples to compare for reproducibility, and then a question one to determine the source. Now for proficiency testing, we actually use, some of the examiners here use proficiency testing, VCM. So this is one of mine from 2017, and they get scanned up front, and then I just pull them off the system and I do my comparisons and issue my findings. I will say that this is actually probably a really good tool for proficiency testing in a laboratory that may have multiple examiners. You understand, if you have one test, now everybody's looking at the same samples, you get a good sense of how everybody's operating when they're looking at the same items, as opposed to a traditional physical test where there's inconsistency in reproduction of the tool mark, which can cause ambiguity in decisions. All right, so I wanted you to kind of understand one of the benefits as far as verification. And for our laboratory, we use a LIMS systems called FA, Forensic Advantage. And this is an actual case of mine. And I was the case examiner. And in this system, it records all the decisions that I was making. So it is a roadmap on how my thought process. Okay, and that's encapsulated. And you would see that within the note package on discovery. And then I will make a request in the LIMS system for a verification by another qualified VCM examiner. And they're not going to know what I did. They go through the process themselves. And you can see this is the verifying examiner in this case. They chose a different path, but they got to the same result that I did. This is really kind of a quasi-blind verification. And you actually see the logic that the examiner was using to make their decision. So we use the LIMS system for tasking. It provides this independent analysis more so than I just hand you a piece of paper and some specimens and ask you to do a verification. Typically when that occurs, depending on the lab's protocol, most often that's going to be an identification that the examiner is now verifying. But here, all the opinions are recorded, whether it's identification, inconclusive, or elimination, and the two examiners are separated. It's paperless, and then I can retrieve the verifying examiner's decisions as well as the images they may have captured to include the primary examiner as well. So I want to show you, this is kind of funny. This is a PowerPoint within a PowerPoint, but this is the court demonstrative aid that we use when we testify. So I've testified just at regular trial using VCM, but we have this little small go-to PowerPoint that just explains, you know, what is the methodology, what are the samples, you know, what brief explanation of class and individual characteristics in the comparison. We show the LCM, and then you can see the last slide on the left, bottom left, here's VCM. So we make that bridge to, these are the two tools that we can use to do the same methodology and what they offer and their limitations. So I'm going to close out with this last slide here. US versus Rhodes is an admissibility hearing that I did in 2023 or 2022 in Portland, Oregon. Very complicated re-examination of evidence. A full day's Daubert, just direct, and having images like this within a packet to illustrate to the court, I think is very beneficial. I had a lot of one-on-one with the judge during the Daubert hearing, and the judge was utilizing the images, actually examining. I could tell that he was examining the images for his own knowledge and understanding to see the detail versus a comparison using LCM. So I would show both the LCM and the VCM as well. Most recently, I did a Daubert in March of this year, US versus Garcia in Albuquerque, used LCM as well. I will tell you that the defense will give credit that this is new technology, it's more sophisticated, may provide better accuracy, but they are aware that there are a lot of tools within this software. And they may give you questions, rightly so, on annotation. This particular package has the capability of using annotations. So you could get crossed on, you know, I understand you took this picture and it illustrates what you were doing as a comparison, but what is it exactly that you were demonstrating here? You know, why didn't you use the annotation tools to illustrate the comparison, or what was important about the comparison? So we have more features, and those are now subject to question by the defense on why or why not you didn't use them. So I think it's a very useful tool, and it has helped the court understand how the science is not is evolving and becoming more sophisticated. And with that, I'll turn it back over to the moderator.
Thank you again, Ray and Eric, for your great presentations. Hi, everyone. Again, I'm John Grassel with the Forensic Technology Center of Excellence. And again, if you have any questions, please put them in the Q&A tab. We do have one, and Eric, this is probably for you. When an ID is made and a verification is performed, is that done solely through the method used that was used to get the ID? For example, if you made an ID with VCM, is it just verified in VCM, or are there times when LCM would be used to perform the verification?
That's a great question. There's something that happened in U.S. versus Garcia in the admissibility hearing there. That particular case was slated for blind verification. And so I was the original examiner and I used VCM, but the blind verifier chose to use LCM. And so in that packet, you see both my work using VCM and the other examiner using LCM, and we both reached the same conclusion, even though we used two different instruments. But there's nothing that prohibits the verifier to using LCM if they choose to, or they may start out using VCM and they decide, I want to look at chamber marks. They can go outside.
Great. And Eric, keeping in mind what you said at the beginning of your presentation, I know that you're not advocating for any particular manufacturer, but a question is, what LIMS program does the FBI use?
We use Forensic Advantage. One of the things that I didn't mention is that several of the companies, we asked them to work with Forensic Advantage. And I'm sure this is true with Justice Tracks or the Beast. They have like a sandbox area where vendors can work within their system. So our Cadre system, as well as other ones, talk to FA. And so they will pre-populate the software in Cadre with the laboratory number and specimen items. So it reduces some redundancy. It's a little more efficient process as opposed to somebody now sitting down at Cadre and now typing in the same information that's already been put into FA.
Great. Ray, with that recent Texas decision that you spoke to, do you see that having national ramifications?
The Texas Forensic Science Commission is quite an active forensic science commission compared to other commissions around the country. So they take a much more active role in shaping the way forensics is presented within the state. I find it, if you're just going to narrow that question, John, to VCM, I think it's encouraging that they're promoting the technology. And I foresee other states as well encouraging labs to adopt the technology. So I think it has that type of influence, not a direct influence, more indirect.
And then I know that you mentioned that part of the decision that was recently made, I might have been in New York, was Detective Fox did not present himself as a scientist. And we know that that still falls under the same kind of court parameters. What are the ramifications, if any, for the field on that statement from the court?
You know, I think it depends on the way the examiner presents him or herself. I would frame what examiners do as both scientific as well as technical expertise. So I don't think we need to pigeonhole in one or the other, because I think it's based on science and there's technical expertise that works through that scientific understanding of the way markings are made on ballistic evidence. So I don't think we have to say one way or another, but I think we can argue both. As an attorney, we always want to argue as many different ways that a piece of evidence is admissible, because then on appeal, it actually is considered by the appeal court. If one argument is wrong and the other argument is successful, they'll just adopt the one. So we as lawyers always want to make as many arguments as possible. So we'll argue that examiners are both scientists and technicians.
Great. Eric, have you validated use of the Cadre algorithm for source determination?
We have not. We have not. We are working on validations as far as in other areas, as far as source conclusion, but we haven't validated their similarity score.
And next question, Eric, is there a chain on the data files generated by scans? And is it considered lab-generated evidence or a sub-item of the submitted cartridge cases?
It's considered lab generated. It does not get a unique identifier. It's not like with cartridge cases that is a lab generated item and it would get its own item number. The case file, it's going to have its own unique identifier with the X3P file and everything that's been recorded. So it says, if you were to look at it, it would say, actually, this is something that we had to learn too. Each item has its own unique identifier, and it depends on the lab. If I were to do 10 years ago, historically, if I fired 5 cartridges, I would just put the lab number on them and the firearm that they came from. But now each one of those specimens gets its own unique identifier, which is now translated into the software. So you can go right back to that specific item that you made the scan with.
Ray, a follow-up question on Detective Fox. Did he or she have a science degree?
No, he didn't.
Okay.
A long time examiner in New York City.
Okay. And I think both of you could answer this next one. In general, how are discovery files provided to entities outside of a lab? Is it from cloud server or other methods?
I mean, I can just answer that. It really depends on the jurisdiction, but if the amount of data that Erich is talking about here is not something that we would probably burn onto a disk and then provide it. It would probably be sent through like a OneDrive or some type of cloud server. That's how we usually share our discovery now.
DOJ has the same kind of tool where they would transfer all the files to the United States attorney involved with the case, and then they would have to turn it over to the defense.
Erich, any thoughts on the preliminary analysis using VCM or LCM for comparison, and then using a validated algorithm for the verification?
I see a lot of utility with that, especially in laboratories that have a finite workforce. If you really want to be able to present to the court that you're doing a lot to assure that some sort of verification is taking place. And so for a laboratory that may have only 3 examiners to have 100% verification is a lot for them to do. But if you had a tool that could provide some confidence that, yes, I made this identification, and based on what we know, the similarity score, that supports my opinion. But just that, yes, that has a lot of utility. It helps those labs.
And if I can just add, it almost seems like that might be kind of the next step in the use of the algorithm before we get to offering it in court, is using it as that verification QA purpose.
Great. I do not think there are any more questions in the chat. Would either of you like any last minute statements or comments? That feel free.
Ray, you scared me with your presentation.
It's just tough because things are uncertain right now. So I think it's good to have a little bit of fear, maybe, because we'll be more robust in our validations and to just consider what the challenges might be looking ahead. So I don't mean to put people in fear, but a little bit of fear is probably healthy for us.
Yeah, it makes you healthier, stronger.
Yeah.
Great. Well, thank you both again. And I know that sometimes questions come up after the fact, but actually we do have one more. Have any of your agencies changed the wording of conclusions to use likelihoods?
No, we're not doing likelihood ratios.
Nor are we.
And thank you again. And if there are follow-up questions, we've posted Ray and Erich's email addresses. And thank you both again for presenting today, and Erich for continuing to present on this activity. Thank you again.
Thank you.
My
Have
pleasure.
a good day, everybody.
Thank you.